Well, hello everyone. My name's Dave Zapponi, and I'm the CEO of Echo. Echo is also known as the Educational Council for Homeowners. I want to thank everyone for participating and attending today. We have over 300 people registered. This is a community conversation on elections and new election laws. Plus, we're going to talk about the CTA, or the Corporate Transparency Act. The election laws will be pertinent to California, and the CTA is a national requirement. ECHO is a 51-year-old statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in communities through education, advocacy, and connections. For today's event, we have a few housekeeping items. These you'll find presented on the screen. This slide deck was sent to all registered attendees prior to the webinar. Please take a moment to review our housekeeping items and familiarize yourself with those. Today, we have a large audience of HOA board members. We will do our best to answer your questions, but may run out of time, likely will, to answer all of the questions. At the prerogative of the presenter, they may or he may answer questions during the presentation or only during the Q&A session at the end of the webinar. We will answer as many questions as possible. I will be answering questions, and Connor will be answering questions as well during the presentation. In addition to the live Q&A session, some answers may be given via text in the Q&A feature during the presentation. To help us prioritize your questions, please use the upvote button in the Q&A feature. That's a thumbs up. This button is located in the bottom left corner of each question in the question box section. Those questions with the most upvotes will be answered first. Simply click on the thumbs up in your thumbs up button in the bottom left of the question button screen, and pick your favorite questions. You can vote more than once for a question, but we do ask that you do that because all questions will be chosen by the number of thumbs up. So the votes that we get, that helps prioritize our answering of questions. Also, please keep your questions short and general in nature. We may pass over some questions that are too long or maybe too specific to your association. Specific questions about your association are best asked of your own attorney and another appropriate expert familiar with your situation. Please use the chat feature to report technical issues and to communicate directly with other participants in the webinar. That's the chat feature, and please use that if you could for non-questions for the speaker. And we do not monitor the chat conversations for questions. Now, let me direct your attention to your monitor, where you will find our disclaimer, which reads, "None of what is said during this seminar shall be construed as specific legal or expert advice from the speaker, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. And the information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes." Thank you. This webinar, as well as all of our events, are made possible by the generous support of ECHO HOA professional service providers. Join me in thanking today's program sponsor, CID Consortium, LLC. Our Q&A sponsor today is Pro Elections, LLC, and our registration sponsors are the Levy Erlinger and Company, LLP, CPAs, and Silver Creek Association Management. For today's event, we will also be giving away a $50 Amazon gift card at the end of the program, courtesy of Liberty HOA Election Services, LLC. To win, you must be present at the end of the seminar. Now we will hear a few words from our program sponsor, CID Consortium. Connor?
HOA board members are volunteers from a variety of backgrounds who face complex legal, financial, social, and maintenance challenges. CID Consortium LLC is proud to support educational opportunities for volunteer board members and HOA members. At CID Consortium, our purpose is to enhance your community living experience.
Okay, thank you. And thank you to CID Consortium. Adam Haney is the president of ECHO, and he's also a CPA, so good company to talk with. Please support all of ECHO's professional members and especially our sponsors. They make our educational programming possible at little or no cost to you. And now for a bit about today's presenter. Cyrus Kuchek Esquire is a partner with Swedelson Gottlieb and provides assistance to community associations in all areas of corporate counsel and transactional work. Cyrus oversees Swedelson Gottlieb's Amend program, which covers the amendment and restatement of governing documents for associations. Cyrus believes strongly in education and participates in many industries specific learning events and is a regular educator in both Northern and Southern California. Cyrus is passionate about promoting diversity and inclusion in all communities and strives to de-escalate and prevent conflicts when possible. Cyrus has authored numerous articles on a variety of community association topics in Common Ground and several other community association publications. Cyrus, we'll need to talk to you about writing for ECHO. That would be nice. We'd love to have you. So at this time, let's turn it over to Cyrus. Look forward to your presentation today. Thank you to everybody.
Thanks, Dave. I appreciate the introduction and being here today. And thank you, everybody, for being here. This is great attendance. We know apathy is a major problem in associations, and we know everybody here today is really fighting against that. And luckily, with some of the changes in the law we're going to discuss today, I think we're going to be able to start turning the tides as it relates to apathy in our associations, getting more participation, whether that be on the board or just in voting in general. So today, we have a lot to discuss. Some new laws, some previously adopted laws, which are now kind of in the throes of operation. And we're going to discuss some of those practices and what's beneficial for your communities. I've already seen in the Q&A that there's some questions that are starting to build. And I just happened to notice that the first one was about election by acclamation and commenting on some of the practices with election by acclamation. So that's really a good place to start, because the first slide and our first subject matter today is about election by acclamation. So that's, I think, fortuitous or a good sign. We're all aligned today. So election by acclamation, not a new law, meaning not this year, but it was adopted last year. There's been some history with election by acclamation where at first there was a debate in the field whether it was really allowed or not. Could you just put it in your governing documents or not? So there was a little bit of a debate maybe in the legal field about that. Then election by acclamation was permissible for certain associations, large ones, over 6,000 properties, separate interests. Now it's allowed for all associations. So we're going to talk about it. What is election by acclamation? It's pretty simple. It refers to uncontested elections and the ability to forego the secret ballot process for an election in a board election if the number of candidates is less than or equal to the number of open seats. So basically, if you have an uncontested election, you don't have to go through with the secret ballot process, sending out all the materials, the notices, the ballots, and really go through that potentially lengthy, costly process when you know it's an uncontested election. So like I said, it is permitted for all associations. And I think a couple really important themes when it comes to acclamation are as follows. Number one, notice. the law and really its intent, it's all about notice. So how can you take advantage of election by acclamation? What do you have to do in order to do so? There's going to be some notice requirements. So yes, we're trying to whittle away some of the costs and some of the processes associated with an election, but there still are a couple notice requirements that you have to avail yourself of in order to take advantage of election by acclamation. So I'm going to get to those notices in a moment. Little delay. Okay. So, and one other thing I want to mention on acclamation, uh, your election rules. And we're going to talk about election rules in a little bit, especially on some of the other items we're going to be touching on today. You technically do not have to amend or modify your election rules in order to be able to conduct an election by acclamation. So that's good news. If you have existing election rules right now in place, you want to take advantage of election by acclamation, you do not have to change your election rules ASAP in order to conduct an election by acclamation. So your next election, you don't have to worry about that. However, we are going to discuss something really important in a little bit regarding electronic voting, where you will have to change your election rules if you want to take advantage. So I'll mention this later, but if you're going to be seeking the opportunity to conduct electronic voting, it's probably going to be a good time to throw in any language regarding election by acclamation so that your members, your board, any management company, so that everybody has that clear guidance directly in your election rules. But for election by acclamation, let's get into the details. And they're frankly not too onerous or not too complicated. The way I look at it is when you want to conduct an election by acclamation, there's really 3 steps involved. There are 2 notices that you're going to have to send out to the community, and then there's the actual formal adoption of the decision in a board meeting. So it's really quite simple. 90 days prior to the deadline for nominations, you have to provide a notice to the community. And really the key item in that notice is a reminder to everybody, kind of an initial reminder that if the number of candidates does not exceed the number of open seats, then the election will be conducted by acclamation. That's pretty much it. That's the first notice. It has to be sent out at least 90 days prior to the deadline for nominations. So I said notice is really a theme when it comes to acclamation. Maybe a subset of that theme is planning. As boards, you're going to need to plan far ahead. You know, whether you're using an inspector of election, a service provider that provides that service, whether you're using a homeowner that's serving as the inspector, whoever it may be, whether as a community you're kind of governing the timeline for all your elections, you need to map it out. If you don't map things out, understand what is your intended election date. Well, based on our intended election date, this is when these notices have to go out. You're going to be failing yourself. That's really what you need to do. And this first notice has to go out 90 days before the deadline for nominations. That's before your call for candidates in almost all cases or most cases. So you're talking about getting ahead of what's usually considered the first step in an election timeline or cycle, which is sending out a call for candidates. Historically, we've viewed that as maybe the first step in an election process timeline. Well, now this is really arguably the first step. 90 days prior to that deadline, send out this notice. Now, the requirements of what has to be in the notice, I mentioned the big one, which is commenting that the election may be conducted by acclamation. That's the key. The statute just lays it out. It lists it out. So what you should do is have a template or a form, work with your legal counsel or your management company or whoever it may be, to put together that notice. So you have it on file, you have it ready, based on your timeline to send out. So that's the first notice, and requirement in the process. Then there's a second. The second, again, quite simple. We kind of generally refer to it as a reminder notice or a second notice. At least 7, but no more than 30 days prior to the deadline for nominations, for receiving nominations, you have to send out another notice. And this notice is essentially the same as the first, but what you're going to do is you're going to add a list of all the qualified candidates as of the date that you're sending that notice. It can't be more than 30 days out. So the idea really is give people a reminder, kind of at an appropriate time and place. But that's really it. That's the second reminder. If you meet those two requirements on those notices, and when you're at the deadline for receiving your candidacy notices, that's it. You're going to be able to conduct your election by acclamation. And so the process there, I'm going to skip ahead a slide, is the board will meet in a board meeting and simply elect those candidates by acclamation. The agenda item, the statute actually says this, the agenda item technically is supposed to list the names of the candidates that you will be adopting or electing by acclamation. So make sure that is on the agenda. The statute lays this out. And again, you should work with your inspector or your management company or even legal counsel if you need any assistance in providing or preparing the forms or the reminder notices, or even just how to prepare your agenda appropriately. But it's quite simple. One thing I wanted to mention, so now I can go back, is when you receive a submission for a candidate from a candidate, you have to acknowledge the receipt within 7 days of receiving it. You actually have to respond basically to that homeowner and provide an acknowledgement of the nomination and a little bit of information, basically stating that are they or are they not a qualified candidate based on what your director qualifications are. And if they're not a qualified candidate, you have to let them know what the procedure is for IDR. There is a statutory term which requires that or provides owners the opportunity to conduct IDR in the event that they're disqualified from serving. So that's something that has to be mentioned in your acknowledgement. But that's really it. So you have the first notice, you have the second notice. When you get submissions, you have to respond to them within 7 business days, detailing the information that's on this slide, a little bit more comprehensively stated per statute. And then the board will meet and elect those candidates by acclamation.
Cyrus,
Sure.
this is Dave. Let me cut in real quick. Can you explain what IDR is? So
Sure.
don't know what it is.
Sure. So IDR is a statutorily driven process. It is defined and refers to internal dispute resolution. So IDR is an abbreviation for internal dispute resolution. In practice, it's a meeting. It's an informal meeting. An owner or an association can make the request upon each other. If an owner makes a request for IDR to the association is legally required to engage in IDR. You cannot reject it. If the association offers IDR, an owner can reject it. And it's really just a process to allow for the potential resolution informally of disputes within an association setting. Typically, they are, they can be quite short. They can be just, hey, we want to hear each other out on something. In this case, so IDR can apply to anything, any dispute in an HOA context. In this case, the reference to IDR is a very specific one. It's that owners have the right to engage in IDR with the association if they're otherwise going to be disqualified from candidacy. And so they have the right to engage in IDR. So that's really IDR in a nutshell. It's like I said, it's informal. It's not to be confused with ADR, which you might also be aware of, which refers to alternative dispute resolution. Alternative dispute resolution is formal. It's an alternative to litigation, meaning mediation with a neutral mediator that the parties would hire, or an arbitrator under arbitration. So there's different forms of ADR. This is IDR. And again, if you have any questions on, what to include in your notice when you're referencing IDR, that type of thing, that's something that you should certainly work with your management companies, whatever's on their form, or if you're working directly with your attorney or an inspector even. One other note on acclamation. Yeah, and I think Dave's commenting on ADR, and it's important to understand that for most disputes, not all, but for most disputes, ADR is actually a requirement. I don't want to get too off topic, but it is actually a requirement before you can sue the other party. So that's why you'll hear a lot about ADR in our association, kind of HOA world. But IDR really can be a great tool. And in the case of a potentially disqualified candidate or unqualified candidate, owners will have the ability to engage in IDR with the association. Now, that doesn't necessarily mean that let me give you this example. Let's say the owner, the candidate, is clearly unqualified or unqualified from being able to serve, and you let them know that. Hey, we received your nomination. You're unqualified. You do have the right to engage in IDR with this on this topic with us. And it's just clear that they're unqualified pursuant to your director qualifications. There's really not a lot that's going to, that's not really going to go far. There's not a lot that can really be agreed to potentially. But, I would say if you have questions on that, hey, we think he's unqualified or he or she's unqualified. Can we even do anything about it? Is there even a compromise or some kind of middle ground on this? If you have that question, I would certainly ask your legal counsel what the specific issue is, and they should be able to answer that quite quickly and simply. I think this slide is a good one. This is FAQ. So I've included some frequently asked questions that I get on election by acclamation issues. And the first one we get is, at what point should the board vote to approve the election by acclamation? So really, the statute doesn't really go into this, the timing, but the practical side of this is as soon as the call for candidate deadline is up, and you've sent out your notices, the call for candidacy period expires. Now you're able to meet as a board and elect by acclamation. So I think that's the simple answer. What should the agenda say? The agenda should reference an election by acclamation, and you should actually have a list of the candidates' names in the agenda. The statute actually says that, so that's the way I interpret it, and that's just the simple way to have an agenda item. But I would have some kind of sub items right under it, just referencing the names of the persons who are going to be elected by acclamation. Another common question I receive on election by acclamation, are the results required to be sent to the community? So we call this election by acclamation. Is it technically an election? The whole point of the election by acclamation is to forego the secret ballot election and really not consider it an election. And so why does this matter? Well, when you actually conduct a secret ballot election, there is a law that states that you have to distribute the results of the election, the tabulated results of the election at that, within 15 days of the election. So are you supposed to do that with election by acclamation? Let's say the board meets in a board meeting, votes, adopts the agenda item, considers those candidates elected by acclamation. Do you have to send out a notice to the community within 15 days? The statute certainly doesn't say so. That's unclear. So I just think it's good practice. Send something out to the community so that it's clear who was elected by acclamation. You're technically not required to do so. So if you have a reason for not wanting to do so, you could discuss that or consider that. But I think the best practice is send out a simple notice that just lays out that the election was conducted by acclamation, and these are the people who were elected. Of course, it'll be in the minutes as well, so you could maybe lean on that. But I think it's a good practice to send something out just to keep, your owners notified and to maybe guard against claims of a lack of transparency. Even though things are in the minutes, we all know a lot of homeowners don't attend meetings. They kind of cry foul. They don't think things are transparent enough. So I think that's a good practice. And if there's no election, another kind of interesting thing here is timing. So let's say you conduct your election by acclamation, but the terms of the currently sitting directors do not expire for another couple months. Technically speaking, there is kind of almost like a presidential election There is kind of a transitional period or a waiting period before those people would take over. So that's something else to consider is you might consider somebody elected by acclamation, but you cannot just kick out a sitting director before their term technically expires. So that's something else to consider. Uh, Another really common question I've been receiving lately is, do we still hold an annual meeting? So usually the annual meeting's primary purpose is let's get people elected to the board. Well, now you don't do this because you've conducted your election by acclamation. Do we still hold the annual meeting? You are still required to hold an annual meeting. Of course, some associations they might have different language in their bylaws, but you are still required to hold an annual meeting, but you're not required to conduct an election at the annual meeting. So what can you do at that annual meeting? Some associations might adopt, uh, an IRS rollover. For excess funds. That's something common we see a lot of associations doing, and that doesn't have to be pursuant to a ballot. You could do that by a voice vote or a hand vote, and that's rolling over excess funds for the tax purposes. So that's an important, agenda item that might be still conducted or carried out in an annual meeting. You also might just adopt the minutes of the last annual meeting at the current annual meeting. So there are some things you might have a president's report or maybe a financial report. Those are also common things we see at annual meetings when you are not actually conducting an election. But the good news is you're saving a lot of money, hopefully, on the balloting process, and just kind of all that comes along with that. And maybe, unfortunately, maybe the most common question I get on acclamation is what if we failed to send out one of the required notices for acclamation, but you still have an uncontested election? What do you do? Well, the whole point of this law is that in order to conduct and carry out the election by acclamation, you are supposed to carry out the procedures. And those procedures include these notices. And it's really not onerous. It's a little difficult from a time and planning standpoint because you have to start so early out and early on in the process, but it's not onerous. And I think there's a good possibility that if an owner challenged the association and said, hey, wait a minute, you cannot conduct an election by acclamation because you did not send out the required notices or one or both or whatever it was. There's a good claim there. There's a good complaint there. So the technical answer is you cannot conduct your election by acclamation if you do that. Now, are there certain associations where there's a lot of apathy? Nobody cares. Nobody will mention it. Nobody will ever say a word. Possibly, but you have to know your membership and you have to understand what the risks are if you're just going to proceed and kind of consider the election by acclamation anyway without having complied with the legal requirements. So that's probably the most diplomatic answer I can give. If you want to risk it, that's a board decision, but there are legal requirements for what you're supposed to comply with. So that's really the story on election by acclamation. I am monitoring the chat a little bit, but I think we did address a lot there. Again, if there's questions on acclamation, we're going to take them at the end in the Q&A. So moving on to recall elections and director removal in general. This is not a new law, but we did want to kind of include this as a refresher for everybody. There are questions all the time about recalls and director removal. And I think in the last several years, really post 2020, when election laws really started to get revamped under Davis Sterling, Davis Sterling is the primary body of law that governs all HOAs in California, by the way. That's the Davis Sterling Act. So what we're seeing more and more now is that recall elections are becoming commonplace. Unfortunately, they can be very costly to associations. They can be very hostile. They can really kind of create strife and a combative toxic nature in the community even, but sometimes they serve a legitimate purpose. And so we want to discuss that briefly today. One thing I wanted to throw in is an important distinction is removing a director. The board does have authority to remove a director, without a membership vote through a recall election. But those circumstances are incredibly limited. And so I get the question all the time, hey, we have a director who is rogue, or they are, they're acting inappropriately. They're being disruptive in board meetings. They've missed 2 meetings. Can we remove them? And the answer, and this also depends on what your legal counsel says, but the answer is largely no. There are certain qualifications allowed by law that you are allowed to impose as an HOA. Certain delinquencies. The Davis Sterling sets these out. Being a co-owner with somebody else of the same separate interest. If your service on the board would result in a cancellation of a certain insurance. So there are qualifications that you are allowed to impose in order to serve on the board. Another is if you've been a member for less than a year. That's an allowable qualification you can impose. You don't have to impose any of those, but many associations, I would say most probably do. Those are qualifications where if they are not complied with, if they are not met, the board can remove a director. And that's considered essentially for cause. Hey, we have a reason to remove you because you are not you do not meet a qualification that you're required to meet, and that qualification is expressly allowed by law. The Corporations Code also sets out a few qualifications: being declared of unsound mind by a court or a felony conviction. Your own legal counsel will need to kind of advise you whether those are enforceable or not, because the Davis Sterling Act sets forth, a very specific set of qualifications in order to serve on a board. And so there is some debate maybe between different firms whether you can still impose these qualifications from the Corporations Code that you see on the screen right now. So that's kind of a little bit of a nuance, but generally speaking, if you have an allowable qualification that you enforce and somebody is not meeting that qualification, then you can remove them as a board. So that's not a recall. But next, we'll talk about recalls. And I think one other just quick tidbit is there is a statute that allows a court to remove a director, but you're talking about quite egregious circumstances or scenarios at play in order for this to occur. This is not your typical just even common strife or kind of problematic issues that a board member might exhibit or kind of get themselves into. Even that is going to be difficult to remove a director via court action. And of course, then you have all the questions about the costs of any such trial. Are you going to recover attorney's fees? Is it worth the time and expense? All of that. So I just wanted to throw it in there just so you were aware that there is the potential for a court action. But I guess the reality is anybody can always sue anybody for everything. So it's not a surprise there is an ability to use a court action potentially. And then we'll get to recalls. And this is what everybody is probably most aware of, which is your standard membership recall pursuant to a petition of the homeowners. A petition of the homeowners carries with it its own, requirements, making sure that they are in fact homeowners, members. What does that mean? It means people who are listed as title owners on the grant deed for their unit or lot or their property. So they have to be on the grant deed. That's what it means to be a member. So you would want to verify signatures that you receive on a petition. It's not 5% of the members who decide whether the board will be recalled or an individual director will be recalled. It's 5% of the members needed to submit a petition to the association. That's the process. Then, assuming that the petition is all appropriate, then you're going to find that you can carry out the recall election process. And it just goes through what I'll call is the standard director election process, where you're talking about the secret ballot process. I think most people here are probably quite aware of the recall process, but we did want to mention it. It's not for cause. The membership can simply seek the removal of a director. Obviously, they're going to be doing so usually for some reason, but technically there isn't a reason there's no reason required or associated with a recall election. So important to note that, if the answer is, hey, we as a board haven't done anything wrong, why are we getting this? Do we have to go through with this? The answer is if you receive a valid petition for a recall, it has to be recognized and you go through the steps and you go through the process. And it's a timely process with time set deadlines, including sending out a notice to the community and setting a date for the actual recall election right away within 20 days of receiving the petition. So you can't sit on these. I do think they are a little bit of a legal process and understanding, your time frames and what's associated with it. So you should reach out to either your attorney or, your manager will be able to kind of walk you through that if you have a management company. All right. And the standard for approval of a recall, it depends on how many members there are. If you have fewer than 50 members in your association, there's a statutory standard. It's a majority of all members. That's going to be the standard. If you have more than 50 members in the association, it'll be a majority of a quorum. So your quorum can come into play depending on where your quorum is set. There is debate about whether a reduced quorum can be recognized or kind of honored as a part of a recall, meaning uh, you don't meet quorum. So can you just say, hey, the recall wasn't successful because we did not meet quorum? This is actually a hotly contested kind of question or issue. I think some people take the position that no, the recall, if you don't meet quorum, it's over. I think some people take the other position that it says quorum. And if it says quorum, technically you can reduce that quorum if somebody makes a motion to adjourn the meeting to hold it with a reduced quorum. So that's a little bit of a hotly contested question. You have to get a legal opinion from your attorney before you make that decision. And I can't give you an answer that you can rely on today because you read the disclaimer at the beginning. I think really your best option to avoid this is if you happen to be amending your documents, your bylaws specifically, I like to add something in the bylaws that says there are no reduced quorums or adjourned meetings for recall elections. No, I haven't seen case law on whether that's enforceable or not. It stands to reason that it would be fully enforceable, but that's something I like to add. So if you happen to be undertaking an amendment project on your bylaws, your governing documents in general, that's an important item that you should consider. And then one other thing to consider on recalls is if your association utilizes cumulative voting, then when you are attempting to recall an individual director or a couple directors, but not all of the directors, it can make it very difficult to have that director removed, director or directors removed. And that's because there's a very complicated formula under the Corporations Code that essentially exists to protect minority rights, minority voting rights. And it's basically to ensure there could be instances here where if a minority of people vote against the recall, even if the required number of people voted for the recall, it could still block the recall. So a minority could really have a lot of power in a recall election if your association utilizes cumulative voting. So important to keep that in mind. And that's another consideration if you are amending your documents. That's something else I always like to point out. If you're intent on cumulative voting, just remember that this is also going to be the case as well. So an important little tidbit there. All right. So just one slide on inspectors of election. I'm really mentioning it because it's going to bleed in a little bit to some of our electronic voting discussion, which we're almost there, I promise. But, nothing's changed with respect to really the practices of an inspector or, who can be the inspector. It is supposed to be um, it is supposed to be, it can't be a board member. It can't be anybody under contract with your association. So management companies no longer permissible, as recent as a few years ago. That was a change in the law. It could be a notary public or a CPA. It could be a homeowner, but with all of the changes in the law and with how complex and complicated things are getting, I personally might guard against using a homeowner, and that doesn't even get into the just the maybe some of the onerous requirements of providing receipts to owners in certain cases, you know, um conducting the mailing or receiving everything and handling it properly, knowing what the laws are. So, you know, I find more and more that as all the laws are getting more and more comprehensive and complicated, and the time more timelines to be aware of, I think it makes sense to use an independent you know, service provider that provides professional services, but that's certainly a board decision, and something that if you have other questions about, we can get into. Now, but the one thing I did want to mention is hybrid meetings. And the reason I'm mentioning this is because I think most people are aware that the law officially changed recently or a year ago to allow for board meetings to be conducted in via virtual means. So, you know, not having to have a physical location present in order to hold a board meeting. And if you're going to hold an election at a board meeting, this raises the question, well, we're going to open up ballots at this board meeting. Well, guess what? If you're conducting a board meeting virtually, there's something in the statute that specifically says if ballots are being counted at the meeting cannot be solely conducted virtually. So you need to work with your inspector about, you know, what does that mean for the potential of a hybrid meeting where maybe you do have to kind of go back to that classic model of having a physical presence, a physical location, as well as maybe opening it up virtually via Zoom or whatever other means. So just know that there is a statutory item that does say solely virtual meetings do not apply to meetings at which ballots are being counted. So I just wanted to mention that because that'll be something that your inspector um, will be able to, you need to work with your inspector on their scheduling and all of that. I think a lot of people think, hey, we can just do everything virtually now. Not necessarily the case, and especially if you're counting ballots at a meeting. Okay. So I think we've made it to maybe uh I think a couple of the most maybe the climax of the program, which is electronic voting, and then we'll follow that up with the Corporate Transparency Act. So a couple really important new issues impacting our associations. Electronic voting was adopted by the state, by the governor. It will take effect on January 1st. Right off the bat, a few important things to talk about. Yes, it takes effect on January 1st, meaning you can technically conduct elections, secret ballot elections, through electronic secret ballot voting starting in January. But there's a lot that goes into this, and I doubt that many associations are going to be rearing and ready to go on this on January 1st. And there's a lot of reasons for that. So first and foremost, let me say this. The electronic secret balloting, electronic voting process, as it currently stands, the way the statute was drafted, does not apply to elections or votes for special assessments or regular assessment increases. So it does not apply to any vote you're conducting on assessments. Very important. And, you know, you might say why. We didn't really find a lot in the legislative history that commented on that. I actually find it a bit strange that you're almost signaling that certain types of votes are more important than others, or maybe conversely, that electronic voting can't be trusted enough for an election regarding a special assessment, for example. So very, you know, very strange, but that's the way the law, that's the law. So we cannot conduct electronic voting for special assessments or increases in regular assessments. When would that come up? That would come up if you're increasing your assessments by more than 20% from one year to the next. And that's all statutory. So we all know that right now, secret ballot voting is required for most elections. The law sets out what elections those are. The primary ones that you're all familiar with are board elections, assessment elections, which we know won't apply here, um, amendments to the governing documents, so any votes on amendments to the governing documents, and, you know, votes on grants of exclusive use of common area, not as common, but still comes up. So really, I think what you're going to find in practice is your board elections and governing document amendments. Those are really the two kind of uh, maybe initially, popular types of elections that are going to that you're going to be able to potentially conduct via electronic voting. Now, another kind of overarching comment on electronic voting. If a member, and we're going to get into opting in versus opting out of electronic voting, but if a member wants to vote by secret ballot, by paper ballots, I think the statute refers to them as written secret ballots as opposed to electronic secret ballots, um, they're entitled to continue voting via written secret ballot. And I don't know about everybody here today, but I certainly know that in most, if not, I would say most, if not all associations that I represent, there's going to be somebody who wants to still vote through the classic, paper written ballot method. So yes, this is a great change, and I'm sure it'll change over the years and kind of evolve, hopefully get cleaned up over the years, because I'll point out a couple, kind of quirks in the statute. But, I think everybody here needs to get comfortable with the idea that there will be hybrid voting, um, electronic and written going forward. Unless you don't want to conduct electronic voting, in which case, an association still has the ability to conduct its voting processes via the written ballot process, what's currently required. So just keep that in mind. Now, the idea is if you do conduct elections electronically, or at least allow for that option, it will increase participation. Obviously, it'll hopefully save on costs with paper. This is especially the case if you're voting on governing documents. I oversee my firm's program on amending governing documents. So I prepare a lot of governing documents, and they're long. They're over 100 pages. And when you're going out for a vote, you might send them out for a review before you even vote. Now you might go to a vote. And so you're looking at all this, sending out to the community, all these distributions of notices. You want to save money. So that's a key factor here. But of course, participation is probably most important. So I think it's a good thing that electronic voting is now allowed, but we have to get a grasp on all of what's required, because there is a lot, and undoubtedly this law will evolve. So I do want to mention that. Okay, so a couple key tidbits, and these are in the slide, and of course I'm happy to answer anything more detailed later on. But opting in versus opting out, this is a key part of this law. Members are going to have the right to opt in to electronic voting and conversely opt out of it. So even if they have opted in, they will have the right to opt out of it. That opt-in versus opt-out process there are some deadlines associated with it. 90 days before an election, that's the cutoff for opting in versus opting out. So basically, if somebody hasn't opted out of electronic voting, they are going to be an electronic voter, assuming they are one, and vice versa. So you can't change it after that 90-day mark. 90 days prior to an election is the cutoff for changing whether you're changing or opting in versus opting out of how you want to vote. Now, this might be the most important thing in all of the program, which is you have to amend. Your association is required to amend its election rules if you want to take advantage of electronic voting. The statute actually says that if an association can conduct electronic voting if there's an election operating rule that sets forth all of the following, and it lists all of the requirements associated with electronic voting. So that means you need to have a rule allowing for electronic voting in order to take advantage and proceed with electronic voting. Most commonly, that rule would be in your election rules. So that's where it should be. And you need to do that. Now, think about timing here. The law doesn't even take effect until January 1st, but you need to amend your election rules. That process alone, that's a minimum of about a month. You have to give everybody a 28-day comment period if you're going to amend your election rules. So you're talking about a little over a month, most likely, to get your election rules changed. When you change your election rules, there's another law that says you cannot hold an election within 90 days of changing your election rules. So the timing here, this is not immediate. If you want to take advantage or put yourself in a position or reserve the right to hold your elections electronically, then you need to get ahead of this. You need to get way ahead of it. So that's kind of my sell job to everybody here today is if you want this and you want to take advantage, the first place to start is get your election rules updated. I assume a lot of firms are doing updates to election rules that they prepared. I know my firm is, and my firm's actually doing an update to election rules we didn't prepare. And it shouldn't be expensive. It's not an expensive process. It's a single section or rule. So it shouldn't, this shouldn't take weeks and weeks for a firm to prepare, but you should get it done if you want to take advantage. And you should do so without delay because of the timing and how this is all going to stack up. Uh, the law is very detailed on the requirements for electronic voting. And frankly, a lot of it applies to inspectors. What does the inspector have to ensure that they're requiring in their, in what they do, as far as authenticating, who can vote electronically and just all of the things that an inspector would normally do. And your association will have to maintain the electronic ballot. So you have to keep records. These are now going to be viewed as association records, similar to all the other ballots and all of that. A couple interesting points that I think are really important. So I mentioned earlier that 90 days prior to an election is the cutoff for opting in versus opting out of electronic voting or vice versa. Before the deadline, 30 days before that opt out, which means 30 days before the 90 days, that 90-day mark. So we're talking about 120 days before an election. You actually have to provide a notice to the homeowners that lists various pieces of information, when they can opt out, whether they're currently opted in versus opted out, a host of items all have to be referenced. So again, we're talking about timelines, and when does an election timeline really start? It's early on, starting with the acclamation notices. Now you're going to mix in this type of notice. So you're talking about a lot of different notices. You really need to map out every single notice required in an election timeline. I would even give yourself a sample election date, whatever your normal election is every year, and map it out and actually, itemize. We need this notice and then this one and then this one, etc. That's what you're going to need to do to keep track of all of this. Tracking, and hopefully if you have management, they will assist in that, and they should be doing that. But there's a lot to kind of digest and absorb on this. And then another key tidbit is floor nominations. Floor nominations are expressly prohibited as it relates to electronic voting. Now, the statute it's a bit ambiguous. It doesn't say whether floor nominations are technically also prohibited for the people voting with the written paper ballots, where you have hybrid going on, where you have electronic voting and you have the paper voting. It doesn't technically say that floor nominations are prohibited for those paper ballots, but it seems to stand within reason that nominations from the floor could be prohibited for all of them, for all voting. So that's something that, I think different attorneys might, they might have different opinions, and you need to understand what they're saying on that. And you need to kind of have guidance, I think, from your legal counsel on what the answer is. But the reality is the statute is not clear on that item. We know for certain that floor nominations are prohibited. I think somebody could say that, well, if you prohibit nominations from the floor for electronic voting, you should treat everything equally. So it should be prohibited for people with a written paper ballot. So that's maybe one line of thinking, but again, it goes both ways. So important to keep that in mind. All right. So that's really, those were kind of I would say the big picture items on electronic voting. There are going to be some notice requirements and opt-in and opt-out requirements. And before I move on, your annual disclosures are also going to have to mention the method by which people can opt in versus opt out. That's something you should add, you're going to have to add to your annual disclosures. And I think what's practical is anything associated with electronic voting, get it out to the community, get it out with your annual disclosures so that you could take advantage of the timelines and ensure that if you're sending everything out prior to the end of the year, now if you're going to hold an election later than 90 days, later in the year, maybe depending on how the timelines work, maybe it's March or April, certainly later in the, middle or to later part of the year, you will have met whatever requirements you were required to meet with respect to electronic voting. Now, inspectors are going to be key in the electronic voting process. I think it's really important that you have open conversations with your inspectors on what are they doing, what is their system, all of that, because inspectors have to ensure that their systems provide for authentication for voting and that they're letting people know how to access the internet-based voting, methodology, all of that. So really important that we get clarity from inspectors on what they're doing. I do think, I've seen the question actually come up. Well, now we're doing electronic voting. How do we authenticate a member's identity? Does it have to be an ID? All of that. So that's interesting. When you're voting by paper, all you do really is sign an envelope, right? So you could just say providing your address and an electronic signature or providing your address, your information. That essentially is analogous to what's being done with paper ballots. So I think that's going to depend on inspectors, but there's going to be a lot that goes into it. There are software systems and inspectors nationally that are, that have already been undertaking electronic voting because it has been allowed elsewhere. In California, it is going to be the first time it's allowed now, but ostensibly it shouldn't be reinventing the wheel completely because there are other states and there are companies that provide those services with respect to electronic voting and the requisite software that's needed. But remember, most associations, you're probably going to have at least one owner. I mean, just imagine all it takes is one for a paper ballot. So, I would go into it thinking and knowing that your inspectors are going to have to be capable of really doing everything. That's going to be something to think about. Okay, moving on to quorum. I'll just comment on this briefly before we get to the Corporate Transparency Act. This is actually cleanup legislation on a law regarding quorum, but I just wanted to mention it because it's not about the cleanup that occurred. It's just about, it's actually about the reduced quorum and taking advantage of reduced quorum. I mentioned it earlier, apathy in our communities is, it might even be at an all-time high. And what I think what a lot of communities want to know is, can we reduce our quorum? Can we just conduct the election anyway? What are our options? And with respect to governing documents that have a high quorum requirement, or, I would say the standard is usually a majority, usually 50% plus one. That's usually the quorum you'll see in a set of bylaws. And sometimes you might have that, and then the quorum will drop for an adjourned meeting to something maybe a little bit less, like 40%, or 1/3 of the members. Well, now there's a statute that basically accounts for associations that have high quorum requirements or higher requirements without a reduced quorum option that's tenable. And what the statute basically does is, and this is a part of Davis Sterling, is it allows associations who don't have a lower quorum requirement and who cannot meet their quorum initially to adjourn their meetings and proceed with a reduced quorum of 20%. So really good news for associations, really to kind of counter and combat what's going on with apathy and allow things to proceed. Now, this is largely going to apply to your board elections. And I say that because votes on assessments, if you're holding a meeting, a membership meeting to vote on a special assessment, there's already a statutory quorum set, quorum being a majority of the community. So that's already set by statute. So I don't want to confuse this quorum, this reduced quorum option with that. That's a statutory quorum. And you might have governing document amendments that have their own approval requirements, such as 51% of all homeowners have to approve an amendment. Or you might have 33% of all homeowners have to approve an amendment, maybe even something higher because you might have outdated older documents. You might have a supermajority requirement. So this should not be confused with those other statutory or other prescribed approval requirements that you might have in your governing documents or that might exist by law. But if you aren't able to meet your quorum, especially again for your board elections, this will allow associations to reduce the quorum to only 20% and to do so 20 days after the original meeting at which you couldn't meet your quorum. And there is a notice requirement that has to go out no less than 15 days prior to the adjourned meeting or the reconvened meeting. So that's all pretty straightforward under the statute, but important for you to hear that today. Understand that reduced quorum is now a statutorily set option for our communities. So really good news there. Okay, so now we're going to talk about the Corporate Transparency Act. This has been, I would say, a really kind of buzzworthy, noteworthy issue impacting our associations. Everybody's asking about it. There's a lot of debate and discussion on it, and we actually have a real-time update for you as of today. And so what I'll say is, and I know Dave's going to talk about a little bit more about the CTA as soon as I'm finished here, but the Corporate Transparency Act is a federal law. It's a national law, and it's really about enforcement against financial crimes and illegal activities associated with financing. And basically I'm going to simplify it here, so I'm paraphrasing, but corporations and LLCs that are registered with the Secretary of State in their state, those companies, they're usually referred to as reporting companies, those types of entities have to file statements basically with the U.S. Department of Treasury's Financial Crimes Network. And I know that's a mouthful, but basically there's a financial crimes network on the website. They have a website. It's the U.S. Department of Treasury kind of sub website. And it's about filing information about your association. Now, what's the real-time update? The real-time update is everybody's up in arms on this kind of industry-wide because unlike a lot of for-profit corporations and entities that are operating, that aren't really changing boards from time to, all the time, we live in a different kind of environment. We live in a world where directors are revolving, right? It's sometimes it's a revolving door of directors year to year or biennial or every other year. And that doesn't even get into the fact that directors resign or are appointed or are recalled. So you have a lot of movement on HOA boards, and it's quite onerous. It can be viewed as quite onerous and burdensome to be updating and reporting on all of the changes with respect to the board as it relates to your association. And we're going to get into the information that actually has to be filed. So what's the update? The update is legal action was actually taken against the U.S. Department of Treasury by CAI actually. And they attempted to seek an injunction to have associations be exempted from these requirements, these Corporate Transparency Act filing requirements. As of today, a preliminary injunction was denied, meaning there is really not much debate as to whether you have to comply with this or not. It's pretty clear cut, and we already thought this was the case, but you have to comply with this, and you have to do so prior to January 1st. So that's going to ensure that, really today gives us a lot of clarity and maybe kind of, I don't want to say finality because that's still going to be ongoing, I assume, but there's a little bit more current finality as to associations having to comply with CTA requirements. So what are these requirements? what they really come down to from an association standpoint is we are subject to the CTA. We are subject to this. The due date is January 1st. We have to file information with the Financial Crimes Network. And what is that information? Well, the association has what's called it's any beneficial owners of an association. Now, what are beneficial owners? In a nutshell, and again, I'm simplifying a lot of this today, but this is really the gist of it. Beneficial owners are those who exercise substantial control over an entity or an association, and it largely refers to senior officers that exercise substantial control. So, as board members of associations, we are viewed as those that exercise substantial control over the entity, over the association. Now, what is the information that has to be shared? It's basically personal information, address, name, and information from your driver's license or passport. That's the information. It's nothing the government doesn't already have. I think we can safely say that. But it does require that you file this information. And again, like I said, because of the revolving door of what can happen, it can be onerous. And more importantly, there's a lot of tracking that goes into it. And make sure you don't forget this, because this is an important federal filing requirement. And there are penalties. And I won't get in, I shouldn't get into it too much to the nitty-gritty, but I will say this. The penalties are quite significant. Failure to file can result in penalties of $500, so significant penalties, that's per violation. There's even jail time associated with the potential failure to file. So these can really rack up, and your association could be in a position where if people are not complying with these filing requirements, your association could be hit with, hundreds, thousands of dollars of potential penalties. And I won't even get into what it means, what potential jail time means. Do I think anybody's actually going to be imprisoned from an association standpoint with some kind of, good faith, non-willful failure to file? I think that's a stretch, but you never know. And it's in the law, right? So that's what we need to be aware of and be mindful of. So keep that in mind. You have a slide here which references what has to be reported and filed from the association, which is the legal name, its physical address, a tax ID, as well as the beneficial owner information, which I mentioned is all the director addresses, names, and your personal information. So really, it shouldn't be viewed as, I want to kind of temper things. It shouldn't be viewed as scary, but it is an ongoing requirement, and that can be viewed as onerous. And there's a lot to just keep track of, and there are penalties. So, we need to make sure that we are on top of things. And before I end or close things out in a moment, I want to say, some associations are likely going to be adopting, I don't know if director qualifications is the right term, but some kind of at least guidelines or something in their election rules about compliance with CTA requirements. And I think, that's legitimate, because what is the association supposed to do if an individual director refuses to comply? Should the association be penalized when you're making clear to everybody who's running for the board, serving on a board, that these are legal requirements and it's out of our hands. These are national, federal requirements, et cetera. So I think that's something you should probably discuss with your legal counsel or whoever's preparing your election rules. What do we do about that? Can we hold a director responsible for penalties if they simply refuse to comply? That's, I think, something that's a conversation. That's a legitimate conversation that you're going to need to have. And as far as reporting, and this is the last slide for me, and then I'll hand it over to Dave. Dave is going to talk about a potential service that can help with this and assist associations and directors. But what this is going to come down to is, as directors, you will have a FinCEN ID when you log in and you you do your filing, and you could either do it yourself or have someone do it for you. And Dave's going to touch on that. But at this time, there's no way to delete a FinCEN ID. So as far as we know, once you're registered, once you do what you need to do, you have a unique FinCEN ID for you. And there's no deleting that. And that might be something that scares people as well. Oh, hey, guess what? Now I have some kind of new government ID number or whatever something analogous that we ostensibly we will call it that, and that exists now, and you can't delete it. Even if I am no longer a board member, even if I move out of an HOA and I say I'm done with HOAs, whatever it is. So that's again, if you have questions on this, I think Dave is going to touch on really somebody you can really speak to and really get some good guidance if you don't want to get that guidance directly from your legal counsel. And I think with that, Dave, we can hand it over to you and you can discuss
Great.
the CTA review.
Okay, well, thank you so much, Cyrus. We'll be taking your questions in just a minute. Maybe you can hit the little carrot for the most votes in the Q&A. Others can go ahead and start voting as we are going to move into the Q&A. But I just wanted to let you all know that ECHO's been saying that we have to comply by January 1st, 2025, since almost the inception of this CTA requirement. So I want you to just remember one acronym here, BOI, BOY, and it's beneficial owners. What's
Information,
information, yeah, beneficial owners information. Just remember that. That's what you really have to maintain. This may be much ado about nothing, but in the HOA world, people in the apathy in the HOA world it's a bit of a problem. And this is just one more little hurdle that people have to do. If anybody has opened a bank account recently, you have to go through this, and you've had to do the filing of all this additional information for quite some time. So this is not necessarily a big step, but it is just an annoyance with respect to most HOAs. So make sure that you use your the advice of your counselor. We're not attorneys at ECHO, but Connor has had a little training on this, and he's available to our members. If you want to give us a call, we're happy to talk with you and help you, give you some direction. If you want to step right into getting a third-party provider of the service to actually help you set up your CTA file, if you will, I would recommend going to Natalie over at CTA Review. You can see the website here. You can set up an appointment and sign up. And she's busy as a bee. You can tell right now we're coming to the end of the year, and all of these must be filed no later than December 31st, close of business. So we need to make sure that this gets done. But Natalie and I have spoken. I explained to her the urgency of this. She knew the urgency, and she said, yeah, we can help your members out. If you want to use a promo code ECHO, that helps us track those of you that are using our service here. And like I said, we do have a couple different layers. We're not attorneys, so we can't give you legal advice, but we can help you understand things. So if you want to call and talk to Connor or send an email, you're welcome to do that. Natalie will be able to set you up. The setup fee is $295. Also, there's a number of the management firms out there that are offering a service to their clients. So you might check with your management firm. There usually is a fee associated with that, but I'll tell you, several management firms have decided they're just going to let you know, and they're not doing anything other than that. And I think that's probably going to be the standard. So it's good to have this resource. Each year, Natalie is planning on, and her company are planning on notifying the boards of directors of the various HOAs, those filing for their BOI records, to let you know that to remind you, if you will, if you have any changes in your beneficial owners, that you need to let her know. And it'll be good. Once you have your number, it's like a social security number, you'll be good to go. And so I'm gonna leave this here a second, and we're gonna pop into the next slide and go into the Q&A discussion. And we have Pro Elections here today as our Q&A sponsor. I want to say thank you very much to Pro Elections for doing the sponsorship and participating. Obviously, this is a pretty good group of people to be talking with and to expose your community to. For those of you who are in the audience here, if you wouldn't mind going to the Q&A feature and putting in your questions, and then or voting, if you will. We'll get through as many of these as possible in the 15 minutes or so, 10 or 15 minutes we have left, so we don't have a lot of time. So we'll go ahead and try to zip through those. Cyrus, if you can kind of work through those pretty quickly, that'd be great. But thanks again to Cyrus for doing this. Let's go to the questions. We'll start off at the top of the list here for the most upvotes. And that is, can you see it, Cyrus?
I do, and I think the question is, if we know that the existing board are willing to remain in place, are we required to have a call for additional candidates? Yeah, I believe you do. You do need to proceed with an election, because what you're doing is you're offering up the opportunity to the membership for your elections. And it might be the case that it's, you know, it'll be uncontested. That could be the case, but that's why acclamation exists. That's why that process exists, which is, hey, if nobody else wants to run, then we don't have to go through with the entire secret ballot election process. So that's really the answer in a nutshell. But yeah, just because you know that the existing board members want to continue doesn't mean you know what the rest of the members are whether they're thinking about running or not. So I hope that answers the question. But if not, my email address is here, by the way. Feel free to shoot me any questions. I am here to help your associations, of course.
Okay, so there you go. So next question here from Lynn. Is this California Director of Elections valid if their HOA election laws are not fully complied with? Who within an HOA is responsible to ensure their HOA election rules are complied with?
Yeah, I mean, associations are supposed to obviously comply with the governing documents. And I think what's important to keep in mind here is anytime an association conducts an election improperly or not pursuant to the required procedures, an owner could challenge an election. And does it mean they always will? Maybe not. But if you're not doing things correctly, an election could be challenged. As far as who within the HOA is responsible to ensure that, I mean, obviously the board is responsible to enforce the governing documents. Owners under the governing documents typically have a right to also, enforce the governing documents. The owners comprise the community. And so there is technically recourse from individual owners. And I've seen it happen. I've seen elections not being conducted properly, and ultimately an owner challenges it. And if the association, doesn't agree or disputes it or just ignores it, well, then the owner could sue. And if they sue, that could be a problem. So,
Yeah, sounds good.
so I think that's probably the simplest answer. There's a lot of offshoots or kind of examples, but that's the clear-cut answer.
So here's the next question from an anonymous attendee. It seems as though professional inspectors of elections don't intend to be on site to count ballots and advise the HOA that many HOAs have ballots counted virtually. Is this acceptable to have a
Yeah,
virtual
so this
count?
goes back to a little bit what I mentioned about board meetings not being able to be solely virtual if you're counting ballots. It is my understanding that a lot of professional inspectors are kind of engaging in a hybrid method where you have a virtual location as well as the physical location, or you have the inspector virtual, maybe separate from where the board is, just because of logistical reasons. And that is generally acceptable. But you really that needs to be ironed out with the inspector, obviously well in advance, because there are, what if floor nominations are allowed? How is that going to be carried out? How is that going to be received? Has the inspector assigned or appointed a designee or an assistant to help, maybe on site if they're not there? So those are questions for the inspector, but generally speaking, the answer is, I think most inspectors, I agree, they're saying that they can do that.
Okay, well, let's move on. That was 14 upvotes there. If a candidate is in violation of their CCNRs, can they still run for a board seat? So about qualifications here.
Yeah, I mean, I there's two answers to this. One, if they're just in violation of the CCNRs, for example, you use the word CCNRs in the question, so I'll just, as an example, let's say there's an architectural violation under the under the CCNRs. That is not a director qualification. So if they're in violation of that, technically they are still permitted to run for the board. Now, if they are not in adherence or they do not meet a qualification that expressly exists to serve on the board, then they could be prohibited from running on the board. But if you remember, we discussed the ability to engage in IDR if they do not meet a qualification. So it's not necessarily an automatic thing. They have to be given the opportunity to engage in IDR if they're not meeting a director qualification that the law allows you to impose. But a violation of the CCNRs, painting the door the wrong color when they didn't get approval, that's different. And that's not something that can prohibit somebody from running, at least as it currently stands.
Okay, there you go. And I think I get that question a lot. And from Kay Dyack, Kay, hello, Kay, nice to hear you. There are 13 upvotes on this one. Can the election rules be amended to require anyone running for the board must be willing to comply with any state and or federal requirements, such as CTA? And a little backstory, I think a lot of the candidacy application during that process, a lot of times they put in there, you have to be willing to file for the CTA number. So go ahead.
Yeah, look, I think this ultimately comes down to what your association's attorney says. I am personally of the opinion that you can and should amend your election rules to have this be something that's there, that's out there. And I can tell you with our election rules, we do address this like spot on. It's as if you're in our office and you know what we're doing. So I do agree. Now, whether you can technically seek the reimbursement of a penalty from a director who refuses to comply, or whether you can kick somebody off, even if you're saying that you have to comply, whether you can actually disqualify somebody and remove them, that's a different question. And again, I think you're going to have to rely on your legal counsel, but it's certainly something we've addressed in our election rules, and I think a lot of people, I assume, will be doing so.
Yeah, and a lot of times statutory law is interpreted in the courts, and ECHO has a program in a couple of weeks that's going to look at the courts in different ways that statutory law has been interpreted by courts, and that'll give you your answer. And I'm sure some of this stuff is going to be adjudicated, so we'll see. Let's go to the next one here. What happens, and this is for 11 upvotes, what happens if by the time of the second notice, there are no names to be listed because no one has yet applied, nominated, or been nominated. But after the second notice, there are less than the number of nominations that you have open seats for. Does another notice go out, or does acclamation occur without owners knowing who might be appointed by acclamation?
Yeah, this is a good question and a tough question. There's nothing in the statute that addresses an additional notice going out if after the second notice, somebody has submitted their candidacy. I think it makes sense that if you're still, the statute says 7 to 30 days before the deadline. I think if you're still in that time frame, even if you've already sent a notice, it could be a good idea to send another notice saying, basically it's a supplemental notice. We've received more, and we're still in that time frame. But if you're within a week of the deadline and, then you receive something, it is late in the game, and there's nothing in the statute that entitles somebody to that notice. So, again, I think, your different attorneys might have different opinions, but that's what the statute says. Or more notably, the statute doesn't say that an additional notice is required if you're not within that window.
Can you push the election date out if you see you're not getting enough candidates in there?
Yeah, you could push the election date out. I mean, I think it's always important to remember that notice is key. And I think what the courts care about, what owners should care about, but what the courts care about, are you conducting an election fairly?
Right.
And are you giving everybody proper notice? And if you have to push something back and your reason or even if somebody complains about it, if your reason is you were trying to do what's better for people, put the notice out there. It would be, in my opinion, it would be difficult to challenge that or kind of hold an association to task for doing something that I think is providing more notice, or pushing something back to accommodate, the reality that, oh, now all of a sudden you got more candidates. But yeah, the statute doesn't require it, so you don't have to.
Okay, makes sense. Okay, Lynn Felsky says if a California director of election is a California director of elections valid when a pre-ballot notice sent to members does not include a correct ballot count per date, per civil code. I don't know this code. You might 5115B. The pre-ballot notice received had a ballot count date less than 60 days from the pre-ballot notice. Ballot count date moved out another month. However, no new pre-ballot notice was sent or given to the members.
Right. So I think in a nutshell, what this is asking is before you can distribute ballots, there is a pre-ballot notice requirement that you have to post for at least 30 days before you can send out ballots. And that pre-ballot notice has to contain the date, time, location of the meeting, as well as a list of all the candidates in the election. And I think if I'm not mistaken, what this question is really asking is something was, incorrect or the date changes. Do you have to post another pre-ballot notice? Again, there's a little bit of it depends in this. I think it's a good practice that if you're changing the date, it or something was inaccurate, that it would make sense to, issue or post a supplemental pre-ballot notice. To me, that makes sense. But there's no clear-cut answer, but I think it also depends on your community, and you have to know your community. And if you think there's potential challenges that await, it makes sense to just provide the notice and do it. I mean, assuming you're not really upending the entire time frame for your election, it really shouldn't impact things significantly by posting another notice, a supplemental notice.
Okay, well, thank you, Cyrus. We're going to have to leave it at that. We're getting really close to the bottom of the hour here when 2:30 we're scheduled to be off. So what we're going to do is our concluding remarks. I'm going to say thank you, Cyrus, for participating today and helping us out. We're going to move on, but you did a wonderful job. And to the attendees in the audience, Cyrus said it. He's got his email there. So Cyrus, remember, you'll get your email box might explode here, but that's what you get. So
Yeah, well, I'll just tell everybody one little mini disclaimer. If it really requires a legal opinion, I don't know if I can do it for free, but we'll do
Okay.
whatever we can to help. And I do encourage people to reach out.
Okay, great. And so thank you to everyone for especially for our members for coming today and supporting Echo and our ongoing Echo webinars. We very much appreciate it. We had over 300 people register today, and I think pretty close to 200 people attended. So thank you so much for that. It's nice to see so many people there. Of course, a large number of you are not members of Echo, so we hope that you would consider becoming a member of Echo. This is how we make money is through our membership. We have probably 80% of our revenues come from directly from our dues, and so in a small percentage from sponsorships and our vendor members. So just want you to know it's really important to have this ongoing and objective resource available to you as homeowners. And the only way we can stay alive and keep going is if you are a member. So we encourage you to become a member. And we also encourage you to encourage others to become members. If you're a manager out there or a professional service provider, please ask your HOA boards to join, or at least to advise them about ECHO. And those of you that are in a position of authority in your HOA, ask your vendors, your management firm, and others that to participate with ECHO and help support us. It's a long road, and we could surely use the support. If you would like to become more involved with ECHO, we have a few opportunities for you. Please refer to the slide. If you see anything that looks interesting, please let us know. We are recruiting volunteers all the time for simple things like just helping us in our meetings, set up tables, or maybe registration, things like that. Or there may be some more other and interesting work, such as administrative work in our database and technology, social media. We're also looking at editors and writers. So that if you're interested in writing something, let us know. We'd love to talk with you about that. And this year, ECHO has launched a new educational program focused on HOA board preparedness. The core curriculum, and you see it on the screen here, the core curriculum is 10 courses. They're designed to be high quality training and available to HOA board members interested in and interested homeowners and any professional, frankly, who would like to learn more. It's a good way to battle apathy, let people know about how to be an HOA leader. It's a good way to do that. Your participation in this program will earn you a certificate if you get through all 10 courses, and you'll have a certificate of HOA board member preparedness. The courses will initially be offered live via webinars, just like this one. And we have 8 of the 10 courses recorded so that you can take those on demand. 2 of the courses are offered only on demand live. So that's the ethics course and the capstone course, which are they have more interaction, and so they really don't lend themselves to having an online program. If you or someone you would like, if you know someone who wants to enroll in the certification program, please reach out to Connor, and his email is on the screen now. So Connor is our administrator of the programs. We are not heading into the final stretch of the resource panels for 2024, finishing up. Our last set of resource panels will begin on November 12th with the Wine Country resource panel. That's in Santa Rosa, where they will discuss holiday infractions. That's always a fun one. Then we head over to the North Bay and San Francisco resource panels on November 13th. North Bay is Marin County, Novato, and San Francisco's south of Market. So that's a really good one. That one will be full. I suggest that you sign up early if you want to go to the San Francisco one. We usually have a pretty good contingent of suppliers there as well. On November 13th, we're going to be going over tree maintenance during the holidays and assessing and preparing associations for the new year. Then we move over to the East Bay. That's in San Ramon on November 14th. We look forward to seeing you there. We're going to have another holiday gathering, and it should be a lot of fun. I think there's some surprises that are going to happen there as well. We also have one larger in-person event remaining for the year. We do 3 a year. This one is on November 16th, and it will be the Legislative Update and Educational Seminar at the Rossmore Event Center in Walnut Creek. If you can't make it live, we are going to be doing a simulcast, and the entire event will be aired via Zoom. So if you're in Southern California or out of state, or somewhere where you just can't take the time to get over to the meeting, we recommend that you join us via Zoom. It'll be simulcast. We have breaks when we go out and talk to the vendors and the suppliers, and so there will be a little bit of a delay during that time, but we will be running programs from our various vendors and suppliers during the break time. So, they'll be on a loop, so you'll be able to see some programs continue on if you care to be part of that. We also will be giving out some really good prizes both to the Zoom group and to the in-person group. Again, the in-person group's going to have a whole lot more, but so just an incentive to get there and be part of it. It's a lot of fun. We're going to give out our awards of appreciation to some deserving individuals that help ECHO. Once again, I want to say thank you to all of our sponsors for making this community conversation possible. Thank you so much. We really appreciate it. And thank you again to Cyrus and Swedelson Gottlieb for doing the presentation today and being a long-term supporter of ECHO and its efforts to educate, advocate, and network with our HOA communities. And of course, thank you to all of you for attending today and making this a successful event. ECHO appreciates your investment in education to foster a better quality of life in HOA communities.